Today I'd like to talk about innovation, the protection of innovation, and how it's a primary driver of economic growth and competitiveness. As an overview, we'll discuss a little bit about the significance of innovation. I'd like to show you some statistics, some numbers reflecting how significant innovation can be. The role of intellectual property. And when I say intellectual property, we know intellectual property covers patents, trade secrets, copyrights, and trademarks. I'm going to focus today on patents. I will touch on trade secrets as well, because these are the two types of intellectual properties that concern technological innovations. I'll talk about some considerations that individuals should take up when determining whether or not to protect an innovation. Now, what is innovation? I think this morning there were some questions about the definition of innovation. The U.S. National Economic Council defines it as the process through which new ideas are generated and successfully introduced into the marketplace. WIPO's recent report, and I would commend that if you have time to read it, it's available online, their 2011 report, breaks down innovation into four categories: product innovation, process innovation, organizational innovation, and marketing innovation and brands. Now, patents and trademarks, technological innovation, primarily are going to deal with product innovation and process innovation for the most part. You can have some on the organizational side, but for the most part, it deals with the left side of the screen here. The marketing innovation and brands, that should be familiar to you as being dealt with on the trademark and copyright side. Now, why is IP so important? Why is intellectual property so important to innovation? Well, it's the result of innovation, and thus serves as one of the best metrics for measuring a company's innovation. We've heard today about how rapid technology is growing today. And for most companies, intellectual properties turn out to be their most valuable asset. And if you aggregate the contributions of individuals and companies, IP serves as a good metric for a country's competitiveness. IP distinguishes a business from its competitors. It's a major factor in branding and plays a crucial role in marketing the company's goods and services. Now, I said we're going to talk about that, the technology side, but you'd be surprised how many clients our firm has that ask, can we mark this product with a patent number? Or can we mark it patent pending? The ability to do so is vital to many companies as a branding tool. IP can be sold or licensed as a commodity in the marketplace. It's sort of the currency of innovation. When you say, well, we're an innovative company, well, tell me how so? Look at the number of patents we have, or we have a collection of trade secrets that we're protecting. It's reflected in the products that are out there. If you have a portfolio of patents that can be licensed, it can provide a significant revenue stream through the licensing. And of course, it serves as an indicator of the country's technological capabilities. We're going to look at some numbers to that effect. This morning, we had a presentation from WIPO on behalf of Francis Gurry, and here's a statement from his recent report on intellectual property innovation. Firms are investing historically unprecedented amounts in the creation of intangible assets: new ideas, technologies, designs, brands, organizational know-how, and business models. Unprecedented amounts. Some of you may have seen this graphic in past years, and it's through 2010 by an organization called Ocean Tomo. And what they're showing you here is that a significant portion of the S&P 500 companies' market capitalization is made of intangible assets, such as patented technology. What that means is, for example, in 2010, 80% of a company's value, if you look on the market, you'll have tangible assets that are on its books, but the market capitalization value is 80%. That tells you that companies, or the industry, the market, people buying the stock, are valuing a company's intangible assets. Of course, their intangible assets are not all patents. They deal with trademarks, brands, goodwill. But you can be sure that a significant portion involves the trade secrets and the patents. Now, intellectual property is, I think, there's no dispute, a primary driver of job creation and economic growth for a company. A recent comprehensive U.S. report that issued just this past March it's a joint from the Commerce Department and the U.S. Patent and Trademark Office, found that protecting intellectual property derived from innovation is essential to the future of a wide range of U.S. industries. Creates both highly skilled and low-skilled jobs, significantly increases wages, promotes exports, enhances competitiveness, and it spurs long-term economic growth. Now, protection of intellectual property is so important in the United States that it's written into their Constitution, that founding document. It states, "The Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries." So this combines copyrights, patents, etc. But look at the words. It's a very short clause with some few words that capture very important property rights. Promote the reason we have the protection of intellectual property rights in the United States is to promote progress of science and the useful arts. And how do we do it? We're securing for a limited time, as you know, patents secure for a period of typically 20 years, a limited time to authors and inventors exclusive rights. That's a monopoly you get. It's the incentive to go out and innovate. So how does IP protect commerce? Provides incentives to invent and create. Why would a company spend billions of dollars developing a new drug if as soon as the drug is out there, generic companies will come and copy the drug and sell it at a discounted price? Protects innovators from unauthorized copying. Facilitates vertical specialization in technology markets. It creates a platform for financial investments and innovation. If you have an idea, and I've heard some questions earlier today, why won't somebody take up my idea? If you've patented it, you have a marketable instrument potentially that you can go out and get funding. Supporting entrepreneurial liquidity through mergers and acquisitions, similar. Think of it as a currency of innovation. Making licensing-based technology business models possible. Yes, IBM is very famous for licensing its patent portfolio. It makes many millions of dollars through licensing. And it enables a more efficient market for technology transfer and trading in technology ideas. Now, let's look at some countries for a moment. Japan clearly recognizes the value of intellectual property. We heard today, I think, about how Japan came out of the Second World War with very little, and yet today is an economic powerhouse. It's a technological powerhouse as well. It was the #1 foreign recipient of U.S. patents and has been for some time. Just in 2010, over 44,000 patents were issued to Japanese applicants. South Korea is following Japan's example. I'd say probably, and we'll look again at some graphics, since the late 80s, early 90s, it's invested a significant amount of its money into R&D, and it's applied for intellectual property protection. And we see that in the U.S. Patent Office, where it's the recipient, second largest recipient of foreign patents. China and India, two large emerging economies, abundant in natural resources, and are also taking advantage of that and going through significant intellectual property development. It's that abundant resources and the awareness of the importance of IP that's creating a combination for high growth that they might, in short term, surpass Japan and South Korea. Let's look at some metrics here. Now this might be a little hard to see, and it's not meant for you to read the detail. But in the recent U.S. PTO and Commerce report that I mentioned earlier talked about patent intensity, looking at a ratio of patents to jobs. And the reason I'm putting this up here is to illustrate how the patenting of technology is an important metric that economies, governments look at to see where the industries are specializing. And in the US, not surprisingly, we see the intensity in computer and peripheral equipment, communication equipment, semiconductor, basic chemicals, medical equipment, machinery. These are all reflected in the top recipients, US companies in the US for 2011 of patents. IBM being number one, Microsoft, Intel, these are all high-tech computer and software industries. Not surprising. Down you have DuPont de Nemours, that's chemical. Here's an interesting statistic. This is from an earlier WIPO report in 2006, a little after 2006, and it's showing resident patent filings per GDP. And I'm not sure if you can read it, but on the left, the number one is the Republic of Korea. South Korea has the highest number of resident patent filings per GDP. The green bar represents the 2006 numbers, and the yellow triangle represents, or diamond represents the 2000 numbers, and you can see they're increasing. Even though their GDP is growing, they're actually increasing their filings. Japan is next, the Russian Federation, New Zealand, China. You can see that it has entered into this race, and then United States, and so on. Here's another graphic I'd like to show you. USPTO patent grants to selected countries from 1980 to 2011. And what's interesting are those two graphics, the two lines at the top, showing that the U.S., number one recipient, continued growth. The U.S. clearly, as we looked at their constitution, clearly appreciates the importance of intellectual property, and they are continuously investing in it. And it's growing. It has been growing at a steady rate and actually at an increased rate since the late 1990s. Next is Japan. And below that, Germany, France, and the UK. Now I've focused in on just two of the countries just so that the scale is a little bit more representative. You can see since 1963, see how low Japan was. It made a decision that they're going to invest in IP. US patent filings have soared since that time. South Korea seems to have taken that initiative to heart in the late 1980s or 1990. And I can tell you from the fact that we represent several South Korean companies, and sure enough, even when there was a downturn in the world economy, in the US economy, the filings from South Korea were going up. They were investing long term. Now here's a graphic that shows US patent grants to MENA countries, Middle East and North African countries. And again, the highest growth rate you're seeing is from India, then Brazil, and then you can see the MENA countries are starting to grow. This is encouraging, especially in the last several years. There's an uptick. I think that's reflected in the importance of IP that's coming to light through government programs, through conferences like this that are just emphasizing for long-term growth, this is what you need to do. Here's some ways of looking at it by comparing patent grants to the GDP, so that it's not quite apples and apples, but it's a closer comparison. We're not going to expect different economies to produce the same number of patents. But as a relative to GDP, you can see from 1963 to 2000, over current GDP, the US #1, because they've been in the business for a long time. South Korea, #4. Look what happens when you look at just 2011. South Korea is #1. And again, the MENA countries, they're, I think, on an uptick. This is patents granted to original filers from the Kingdom of Saudi Arabia from 1990 to 2011. That's some significant growth there. If Saudi Arabia continues at this growth rate, you will see numbers like South Korea very, very soon. You can see more than the doubling in recent years. So what is it about the MENA countries that's important? They can leverage their intellectual property. Well, historically, they're the longest term of established centers of learning, universities, education centers. It's a young, dynamic, and talented population. The World Bank has printed studies on this. It's a very young population in the Middle East. Resource-rich countries that can provide funding. Funding is always important. Attract foreign investment for additional funding. It's a large geographic region. It has a large gross domestic product. These are all ingredients, along with its geographic location, all ingredients for economic growth. Now, as an intellectual property attorney, and I focus mainly on the protection and enforcement of patents, what is just critical is the ability to characterize. When I say characterize, I mean define your intellectual property. You can go to a company and say, oh, I've got this great idea. I'd like to share it with you. Will you give me some funding? And they're like, wait a second, before we invest, exactly what is your idea and how is it protected? Can you define your idea? And the patent system has been designed to force you to define your innovation. We all know what a patent has at the end. It has a set of claims that define your intellectual property right. No different than buying a piece of land or a house, and you go to the place where you record the deeds, and you know exactly what you own. Well, the patent, along with a body of law, gives you some sense of definition. So, by characterizing innovation, you can leverage it. And what do I mean by leveraging? Each innovation is a potential business opportunity. Companies need to continuously contribute to technological advancements, and they need to be aware of their competitors' advancements. They have to maximize the commercial value of the company by maintaining trade secrets for certain types of innovations that are better protected as a trade secret. They need to enforce the right to exclude others for their patented, protected technologies. They need to license in technology, and they need to also take their own IP and license it out if they think, if that's the maximum benefit they can obtain from that patent. They should participate in joint development agreements, and here again is where patenting facilitates that activity. Let's focus a little bit on two types of intellectual properties: the trade secrets and the patents. I mention here, if you have an innovation you're not willing to keep as a trade secret, you're not willing to invest in the patenting, well, share it with the world, publicize it so no one else can independently develop it and exclude you potentially from using it later on, because once it becomes public knowledge, it's in the hands of the public. It cannot be protected. What are the characteristics of trade secrets? They cover technical and non-technical information. They derive their economic value from not being known to others, from being secret, not being readily ascertainable. not being readily ascertainable is key. You can't reverse engineer the trade secret by looking at the product that's in the market. Suitable mode of protecting new discoveries in an industry with few competitors monitoring each other closely. If it's a very competitive environment, it's harder to keep trade secrets, especially in today's economy where employees are moving from one company to another. And it potentially has an unlimited duration. We talked about the 20 years protection for patents. Trade secrets are potentially unlimited. The formula for Coca-Cola or Pepsi will not be disclosed, and they'll protect that indefinitely as long as they maintain it a trade secret. Patents, on the other hand, they are a government-granted monopoly in the sense that it gives the patent holder or the owner an exclusive right, a right to exclude others. It's not necessarily a right to practice the invention, but practically speaking, it ends up being an exclusive right to practice the invention. It must be technical. You look at the United States Patent Office requirement for, I think there was some discussion, what's the definition of invention and innovation? Well, an invention can be patented, and to be patented, it has to be new, it can't be obvious, and it has to have utility, and it can't be something that's occurring in nature. Well, it must be technical. It requires disclosure of the patent technology to the public. Well, that's why the government is giving the monopoly. It's the quid pro quo, the exchange. If you disclose your idea to the public, we will give you for a limited time exclusive rights to that technology. And the idea is that your technology will be put into the market. You will use it, you will commercialize it, you will leverage it, others will benefit from it and develop their own technology building on it. And that's the model closely followed in the US, Japan, South Korea, and of course, throughout Europe. Here's a comparison between patents and trade secrets in a little more detail. We talked about the limited protection of patents, unlimited duration of trade secrets. Trade secrets are suitable for technologies that are expected to have a long commercial life. Patents, on the other hand, are suitable for technologies, particularly computer technologies, that might have a limited life, where their maximum economic value, the maximum value through its commercialization occurs shortly after the patenting. Trade secrets are obviously suitable for technologies that cannot be easily reverse engineered. Certain processes that take place behind closed doors, and to the extent that a company is confident that it can implement procedures to protect the trade secrets, then it might be the way to go. On the other hand, patents are suitable for technologies that can be easily reverse engineered or cannot be easily protected. Some examples below for trade secrets: manufacturing chemical processes, computer algorithms. Unless you have the code, it might be very hard to decipher, to reverse engineer it. Food technologies and financial services. On the other hand, not surprising, pharmaceuticals, electronics, and heavy machinery, things that are traditionally protected through patents. What about the enforcement? And when we think about intellectual property, its value comes through the ability to enforce it, to keep others from copying or stealing it. Well, trade secrets, anybody can practice the same technology without ramification if they independently come up with it, if they don't misappropriate it, if they don't steal it by breaking confidentiality agreements. So there's the risk there. Patents can be enforced even if somebody else independently comes up with the idea a little later on. It's okay for people to reverse trade secrets. It's not okay to reverse a patented technology and to practice it. When you go to enforce a trade secret, and we've had this occur many times in litigation, the difficulty to enforce a trade secret in litigation in the United States is at some point you're going to be asked to disclose, at least at some level, what that trade secret is to prove that the other side is misappropriating it. The defendant wants to know, well, you're accusing me of misappropriating a trade secret, what is it? You have to disclose it. It's a dilemma. which is why a lot of trade secret cases settle early. On the other hand, patents, the scope of the protected intellectual property is well defined. It's out there. It's already been disclosed. Under the law, it has to be disclosed. So characterizing, I mean defining innovation is key to leverage in IP because it's a prerequisite, I put it here. It's not just key, it's a prerequisite to leveraging IP. You need to know what your innovation is in order to know how to maximize its profitability. You need to know what it is before you decide how much money to invest in it. The gentleman asked a question about, I think, going to a car dealer and said he had an idea for an automotive technology earlier today, and response was, we'll go build a plant or something like that. Well, if you have it written down in a patent, it's marketable. You can disclose it without fear that someone's going to steal it, as long as you can enforce it. Characterization is required in order to license a trade secret or patent. It's required in order to decide whether to continue protecting the trade secret or a patent. Protecting a trade secret, patenting a trade secret, paying annuities, these cost money. You have to characterize the technology and continuously characterize it, especially in the context of your business, to decide whether to continue investing. Now, companies make little effort to define the scope of the technology for trade secrets. By definition, because they are trade secrets, there's no rigorous process to sit down and draft an application with a patent attorney, draft claims, file an application, have it examined by the patent office. That doesn't happen. And so by its nature, trade secrets don't get defined as well. The patent process is a rigorous process. It forces the patentee, it forces the inventor to sit down and think about his or her invention, to come up with a definition for it. What is it really impacting? What is it all about? What's the property right I expect to get out of this? Here's a sort of a timeline for obtaining protection. You come up with the invention, conception, and the reduction to practice, as we call it in the United States. You disclose the invention to in-house IP department. We call that an invention disclosure. The attorney interviews the inventor. They draft the specification. This is all characterization of intellectual property. By the way, it's all costing money, too. So along the way, these decisions have to be made. At every milestone, do we continue investing in this technology, continue not just in spending money in the R&D to generate the innovation, but spending money on the legal side to protect the innovation? You go through the application process, you get an issuance of a patent, and then you pay annuity fees, and that's money being spent even after the protection. Many companies go and review their patent portfolio to decide, is it worth maintaining the annuities on these patents? And they will say, no, we're going to stop, let the patents expire, because they don't have any commercial value as far as we can see at this time. So this is, again, part of the rigorous process. Invention disclosure form. When we sit down with an inventor, we ask the inventor, fill out this form. It sort of has categories to guide the inventor through the disclosure. Identify the background of the technology. Describe in your best words what the technology is about. Identify the inventors. It's in the United States, it's more critical than it is in the rest of the world, and that's going to change with the new law that's being implemented in the U.S. But still, it's important to know the inventors because you want the invention disclosure to be complete. Identify competitors and economic benefits. That helps you visualize or anticipate, well, how is this invention applicable? How should I draft the claims at the end to capture the broadest scope I can that I deserve as an inventor, and preclude others from practicing that technology, even if it's not the same technology for which I initially spent the last 3 years researching. It might have applications well beyond those of the business. Okay, so I will just, another thing about patents and the ability to leverage, it's a well-developed body of patent laws. It has no meaning to have a patent, no economic value if you can't go and enforce it. If you can't go and read the patent, sit down with an attorney and say, what is it I can do and what is it I can't do? The developed body of patent laws allows you to do it. We talked about the claims, and I won't go through here because my time has run out, but the claims at the end actually define your intellectual property in precise terms. When there's litigation in the US, the litigation is about those paragraphs at the end of the patent. What does that mean? Am I inside the property right defined by that claim, or am I outside the property right defined by that claim? Point on claim drafting. We do this in the US a lot. We start out with the broadest claim, and then we narrow. We take the inventor's idea, and typically the inventor believes his or her idea covers this scope. And we say, no, your idea, let's take out all the miscellaneous. It's really, your intellectual property right is much broader. Let's start with the broadest claim, and then we'll add more claims, paring it down to something more definitive that actually fits the commercial implementation like a glove. Now, I won't talk about in-house procedures here for characterizing intellectual properties. I'll just touch on it briefly. It's this awareness concept. We need to be aware in a company of innovation. And there should be a formal process. Many large companies have an IP department, and there are incentives for the engineers in the companies to sit down, fill out disclosures. They might get rewards. But the point is, they go through a formal process of disclosing the invention. The IP department, together with the R&D department, sits down and with the marketing department, looks at the potential commercial value. Do we proceed? First of all, do we maintain it as a patent? No. Maintain it as a trade secret? No. Leave it to the public? Whatever it is, it's a formal process. Characterizing intellectual property is just so fundamental. I can't overemphasize it, in order to be able to leverage any innovation a company comes up with. All right, thank you. Should I take questions now? Yeah.
Thank you very much. It's okay. جلستنا الثانية بعنوان استراتيجيات ومتطلبات تسجيل براءات الاختراعات يقدمها لنا دكتور هانز جودار شريك في بويمارت اند بويمارت. البروفيسور هانز جودار محامي براءات اختراع وعلامات تجارية في ألمانيا وفي الاتحاد الأوروبي، حاصل على شهادة دكتوراه في الفيزياء. يعمل كبروفيسور في جامعة بريمن في ألمانيا، يدرس فيها قانون براءة الاختراع والتراخيص. يعمل كمحاضر في مركز ميونخ لقوانين الملكية الفكرية MIPLC. بروفيسور زائر في جامعة سانتا كلارا في كاليفورنيا في الولايات المتحدة الأمريكية، وفي جامعة واشنطن في سياتل، جامعة شينشي في تايبي، وفي جامعة توكاي في طوكيو. يعمل أيضا بروفيسور مستشار في جامعة هاوزهونغ في ووهان في الصين، وهو عضو من أعضاء لجنة الأساتذة في المنشأ العالمي للملكية الفكرية الواقع في جامعة بكين في الصين. أيضا من أعماله قاضي مساعد في مجلس الأعيان لشؤون محامي براءة الاختراع في محكمة العدل الفيدرالية الألمانية، وكذلك مدير في المنشأة العالمي للملكية الفكرية في دلهي، ورئيس سابق لمنظمة خبراء التراخيص الدولية وجمعية خبراء التراخيص في ألمانيا. تفضل دكتور هانز.
Yeah, if it is possible, I would very much appreciate if this little microphone, which I just tried to attach to my tie here, could be energized, because it is difficult for me to stand here. I would like to walk a little bit around, but I think no, if not, it's okay. Okay, I stick to this one. It's fine. So, okay. Doesn't work, so I wanted just to make sure that, because it is shortly before lunch, that you don't fall asleep. I will not fall asleep because I have to speak, but if I would move a little bit, it would be more difficult for you to fall asleep, and I thought I can keep you awake. But anyway, I can try it like this, no problem. Some of the items I have already heard now. I wanted to talk about them to you. In the speech before, we had changed the order a little bit, but there are some aspects which I would like now to take the opportunity to focus a little bit more on than I would have otherwise had the time if I would have had to explain differences between trade secret and patent protection and all these things. I would like to start with... You think so? I tried it already, but it didn't work.
You think so? Let me put this away.
Okay, thank you. Fine. Perfect. This is just fine. I would like to talk about a few things which otherwise I could not have had the time really to talk about. And what I would like to, this is another thing. I'm now geared up with many things here, I think, currently. Okay, fine. This I don't need, actually. This is like in a circus, maybe. Let me see. Now I feel free and have only this thing. Thank you. First of all, we heard this morning about something, and it was a very philosophical question to me that was talked about, namely differences between innovation, invention, how you can promote in a society, in a country like in the Kingdom of Saudi Arabia, the being prepared to make inventions. There were some comments by Mohammed Al-Ansari, for example, on this. And I think the key word, for me at least, is that you need a reasonable harvesting system for inventions. This harvesting system must make two things sure. That first, and we have to differentiate really, between individual inventors, people who are creative, who try to make innovative things, and the bulk of the inventors of this world. And maybe this is not so clear to the whole audience here, who are, at least in Germany, for example, to about 98% employees. 98% of all inventions coming out of Germany are employee inventions, whether in private industry or in universities and public research institutions. 2% come from individual inventors. So the individual inventors are a poor and maybe in some countries ignored minority, but I would like, just because they are minority, to start with them. What can a country do? What is most necessary for individual inventors to make their inventions available to the public and also to make their inventions, at the end of the day, commercially beneficial for them? I think what a country must do is they need a collective system where inventions are collected by somebody who has some kind of a fund, maybe public money available, in order to help the inventors, who usually don't have money anymore beyond her own private R&D, which leads to the invention, to protect them by a fence around the invention with a door. This is the scenario for a license agreement. You have learned this already before. What the inventor creates is a piece of land, intellectual property, where nobody respects the limits, and the inventor has to erect a fence around. And if he decides to make this fence out of patents or other intellectual property rights, IPRs, intellectual property rights, are nothing else than the fence to define the border and make it hopefully unpenetrable around this intellectual property. These are expensive. Patents cost a lot of money, and you will maybe have missed one item difference between trade secrets protection and patent protection in the lecture before. The biggest difference is that trade secret protection comes for free if you take the necessary measures in your own environment that not others know what you have invented, and patents are tremendously expensive. They are not expensive because the patent offices of this world are expensive, but because the patent attorneys of this world are expensive, including me and my partners, and other firms, not to speak of United States even, where they are much more expensive than in Europe. So, patents cost money. And where should a poor individual inventor get this money from? There must be a fund available who tells the inventor, I take your invention against the promise that later on, if I am successful to protect it for you and maybe even to commercialize it later on by permitting others to use it against license fees, that we share the income. Maybe that you, typical model in Germany, inventor later on gets 25 to 30% of the income which I can get out of licensing, out of what I have created now, intellectual property surrounded by a fence of intellectual property rights. And I get 70%, and out of these 70%, oh, I get 30%, you get 70%, sorry, that was wrong. 30% gets the institution, 70% the inventor, typical for Fraunhofer in Germany. Out of my share, I bear the risk for protecting, for filing, for commercializing, etc. So this is a system which a country needs. I know in Europe only one country which nearly perfectly has organized this, and this is Finland, where they have a fantastically working securing system, collecting system for private individual inventions funded by the government originally. Nowadays they have enough royalty income out of their continuing commercialization that they can take care of individual inventors in this manner. And I think this is a task, a big task, for a country like the Kingdom of Saudi Arabia. What do we do with securing of the other inventions, of employee inventions? How do we make sure that the employees do not only make inventions? I think they do. A good worker, a good researcher, out of his own drive, of his own intentions, will always create new things that potentially are commercially useful. But the employer needs to know about this first. There must be some incentive preventing that the inventor in the evening, 5 o'clock, goes home, or as I heard recently in Australia, 5 o'clock is surfing time, goes to the beach and finishes work, but sits down still and writes an invention disclosure, maybe of 2 pages only, a letter to the employer where the employee says, I think that we could do this and this better than we did in the past. There must be an incentive for that. And I have always said, also here in the kingdom, whenever I had the pleasure to work with companies and to speak with companies like Saudi Aramco, like SABIC over many years, an incentive system is, since we are all human beings and human beings wish to see some benefit of what we are doing beyond our duties, we need some kind of an incentive system. And we have had this in Germany since 1942-43. And this is, I wish to point to, and then I will talk about how you can take the appropriate steps in your companies to go, in spite of the expensive character of patents, into real steps of obtaining patent protection, how this was done. My country was in 1942-43, just shortly before losing World War II. And some wise people in the government thought, we must get more inventions. And in the German sense, we don't have the wonderful US Constitution. In the German sense, we have a very modest patent law. Inventions are technical inventions, and that means technical solutions to technical problems. Nothing else. No business method, please. Nothing else. Only technical solutions for technical problems. These are inventions. And this is what people in 1942-43, 2 ministers in the German government at that time, thought would be necessary to possibly win Second World War. This is really the actual history of our famous or infamous law concerning inventions made by employees. It was created in 1942-43. It means essentially that each worker, each researcher, whoever makes an invention in an employment situation gets an extra bonus, which depends on the success, the commercial success the employer gets out of the use of the invention later on. A little percentage, a fair share, as the law says, and it would not be Germany, of course, if there would not be a long accompanying regulation to the law which prescribes how to calculate the remuneration. But this is not the decisive thing. The decisive thing is there must be some kind of an incentive, a financial bonus. How it is calculated, not so important. What was the result? The result you could see from the statistics we saw a little bit earlier today. Out of Germany per year come still more inventions today than together out of United Kingdom, France, the Benelux countries, and Italy. More inventions per year. Why? Because the Germans are so intelligent? I don't think so. I know very intelligent French and Italian and British inventors. That's not the point. The point is, because the Germans get this incentive. There is a harvesting system, like a vacuum cleaner, which takes the inventions away from the inventors and at the same time gives something back. Every inventor knows, if I sit down tonight for 2 extra hours, write an invention disclosure, a letter to my employer, I can be sure that next month or 2 months later, I have an initial extra payment, not of too much money, maybe of a few hundred euros. And later on, if the invention is commercially used, only 90% of the inventions, by the way, are ever commercially used, 90 to 95. The other, only 5 to 10%, the other 90 to 95 are never used. So only 5 to 10% are ever commercially used. And in that case, the employer pays beyond this initial payment an extra success-dependent fair share. This is our system. The success is more inventions coming out, and maybe this is also something to think about in the Kingdom of Saudi Arabia, and I think there are many people already thinking about this, whether not by law you would make sure that employees get this extra thing. Now, after you have that system, incentive system to create inventions, to make them notified to employers, on the other hand, you need now a patent system, which does the best for your inventors. And what is the purpose of a patent system? And this is something where we don't find this, unfortunately, in the United States. But I think this is a tremendous important task to keep this always in mind. Patents are, in principle, obstacles against the driving force in our competition-driven economies, in which we believe in the Western countries. Might be totally different if you look into a socialist planned society. That's at the moment not on the table. We have a competition-driven economy. You have it in the kingdom, we have it in the Western world, we have it in Europe, in the United States, in Japan, and China even. And patents prevent free competition. Never forget this, because your patent is good for you. You get it to prevent that others imitate freely your innovation. But others cannot go into that area anymore. They have to do something else. They have to go around. David Simon, the outgoing chief patent counsel of Intel, a good friend of mine, said recently in an IPO, Intellectual Property Owners Association meeting in the United States, the patent system was created to promote innovation and inventions. Today, I have the impression it is more an obstacle against innovation. Why? Because your patents protect your innovation. You have something which you can commercialize then. But the others also get patents. And patent thickets are created which prevent the putting into the market of your innovation. So to make innovations is highly under an incentive drive. You get incentives for that. But there are the many patents of others which make it more and more difficult to put your new product into the market. And this is the reason why we have these giant smartphone patent battles all over the world. In Germany, I'm also involved in those. The Microsofts against the Motorolas, the Googles against Apple, I don't know what. And in other countries the same, not to speak of Samsung. So what must the patent system do and your patent office? Create good patents for good inventions. Very important. And create them fast. Make sure that inventions by your own inventors, by domestic industry, are quickly searched and examined so that before the 1-year priority term, because patents are regional, country by country, before the 1-year term ends, where you can practically still go into foreign countries and obtain patent protection, the inventor, the company, has a first examination or search report available to make a reasonable decision. Should I invest now beyond my 3,000–4,000 euro filing cost maybe for my domestic application in maybe Saudi Arabia? Should I invest the next 50,000 for the following necessary steps to get foreign patent protection? And the patent office, if it is well established, the patent system, can make this decision for the company and inventor and university much easier. That makes it necessary that you have good examiners, enough examiners, or at least outsourcing possibilities that your patent office can give this task of a quick search and examination to other countries. And you must do what Germany does, and the European Patent Office does, by the way, in full conformity with TRIPS, that domestic applications, I will immediately correct this, but for the moment I say domestic applications, applications by your own companies and inventors are searched and examined with priority. Because if you examine all applications which come and flood your patent office with the same speed, you cannot do anything faster because it is much too slow. All patent systems of this world have a backlog of, well, in the United States, a couple of 100,000. In Europe, I think 60 or 70,000 applications. You cannot treat them all in the same manner. And Europe, particularly Germany, has the rule that you examine first what is filed without claiming a foreign priority. That means domestic applications at the end of the day. You don't exclude foreigners. If a Saudi company, if a Japanese company wishes to file at the German Patent and Trademark Office in German language, fine, first application, of course, will immediately be examined. That means 6 to 8 months later, you have your first examination report. No discrimination of foreigners. And indirect, of course, because not so many people wish to draft their patent applications in German language. And might be in Saudi Arabia, not so many foreign companies, the Chevron Texacos of this world, might wish to file in Arabic and to draft their patent applications in Arabic. But by following these measures, you get a priorization. You get an early examination and search system for your own inventions. This is, I know, a political question. I wanted just to mention it. Next step, and we come to that obstacle for competition, what your patent office must be able to do and your whole system, to destroy junk patents. I personally believe that 70 to 80% of all patents in this world, and actually statistics show this, are invalid. They are not worth the paper on which they are written. Why? Because many patent offices don't examine at all. Others have a much too low standard for inventiveness, for non-obviousness. They give a patent, a huge patent, for a very small invention, which is not good. So you need a destruction mechanism where people can cheaply, quickly destroy junk patents. Where do you find this? Well, all over Europe, in China, in Russia, in Japan. Do you find it in the United States? No, absolutely no. It is difficult, it is expensive, and practically for somebody who has not indefinitely deep pockets, impossible to destroy patents as quickly as they need to be destroyed in order not to be unjustified obstacles. AIA, I know, the American Invents Act, this wonderful instrument which will now bring a reform of US patent law, try to rectify it to some extent, but there are so many flaws we cannot talk about this, but my American colleagues know where I am talking about. This does not change too much. It is a first step in the right direction on a very, very long way. But you need this system here. I don't know whether it exists. I'm not an expert in Saudi patent law. You need an opposition and invalidation system which is open to everybody, where you do not need, like in other countries like the United States, a legal reason to try to destroy a patent, but where you looked at, like in Europe, friendly. If you try to destroy a patent by opposition at the European Patent Office or the German Patent Office, or by invalidation action at our courts, you are considered to be a friend of the public, to act in public interest because you help to re-examine the patent grant and to remove the patents from the register and therefore make competition easier, make the thicket of patents surrounding innovations a little bit thinner and more penetrable. These are the general rules. What should you do as a company? Well, you should obviously file first in your own country or in any other country which you might wish to find with a quickly searching and examination system, and only one application. I would not recommend to go into external searches and evaluation for many reasons. The main reason being you spend for an external patent search and the opinion of your patent attorney already more money than you would spend on drafting a patent application as a test application and filing it at a good working patent office, like your domestic patent office or the GCC patent office. If your search, look at that, would result in getting the knowledge that your invention is not patentable, fine, then you would have spent already, say, 4,000 euro or US dollars. And nothing would have happened, nobody would have known about your invention. If, however, your search leads to the result, this is a patentable invention probably, your own patent office would tell you immediately when you file a patent application, then you have nothing than a search result. Then you still have to file a patent application at your patent office and add the next 3,000 to 4,000 euro on top of it. So my recommendation is no searching, no opinions by expensive patent attorneys. Immediately draft a patent application and throw it at a good patent office. The patent offices of this world, the good ones, and certainly yours here are good ones, or at least on their way to get even better and better, are the cheapest searchers and examiners you can find. Much cheaper than private patent attorneys for the simple reason public servants usually are paid less than people in private economy are. So this would be my recommendation. One first application after, and then before 6 or 8 months or 10 months are over, you would have the first search result or examination result. What do you do then? Then you go for the international threshold, go please into a PCT application. Patent Cooperation Treaty, fully available to everybody, even for countries where might be at the moment not yet access to PCT is directly given. You always can use a co-applicant from a country which is a PCT member, and this gives you entry into the PCT system already. What does that mean? That means that towards the end of the first 1 year I have talked about, after your original filing date at your patent office, you don't spend 50,000 euro for 10 countries to cover them with patent applications to get parallel foreign patents. And you need parallel foreign patents nowadays. We have a globalized economy. No use to have patent protection only in one country. You don't wish that a patent which you have protected here in Saudi Arabia is taken by Schlumberger or Halliburton or I don't know where to somewhere in Kazakhstan or so and freely used there. You need wisely used countries, wisely selected countries where you have parallel protection. And you don't now invest the 50,000 euro. You invest just 4,000 euro into a PCT application. By doing that, you buy time, 18 months beyond the Paris Convention 12 months priority term. And after these, in total then already, 30 months after your original filing date, where you filed your test application, then only you invest in those foreign countries where you wish to have patent protection. Then you spend per country again, minimum 5,000 euro. But first of all, the number of countries might already be smaller because you have in the meantime seen, if you are a pharmaceutical company, that 5 out of your 10 candidates don't fly, they are toxic or ineffective. Your commercial people may have told you, oh no, we don't wish this bicycle, we wish the other one with 4.5 wheels, not only with 2 wheels or something. All these things will reduce the number where you have really to file. And then you save money. And even if you would theoretically know already, and this is the end of my presentation, you would already know at the time where you go into PCT 1 year after your original filing date, if you really would know with precision those countries where you later on need patent protection, the sheer shifting of the investment of 50,000 euro from 12 months after your original date to 30 months after your original date, by 18 months, saves you more bank interest than the whole PCT application has cost you. Because you invest 18 months later 50,000 euro. You can calculate this yourself. And you must always calculate like this. Some people say, yeah, but I have the money. I don't have to lend money from a bank or so. This is, of course, not the right consideration. Then you need the money for something else. But this is the way how to do it. So PCT applications file themselves. The former head of IP of Robert Bosch GmbH, Bertram Huber, free consultant now, very good friend of mine, he has introduced this system with Bosch, and this is publicly known, everybody knows this, and they say they save with security, they know this, with guarantee. Per patent family, they file about 2,500 euro by using PCT. When you imagine that they file 3,000 international patent families, and really international ones, covering the world, per year, this is a lot of money. These are 5 to 6 million just for free, just into the pocket, by nothing else than by a little change in your internal procedures, which finances a great part of their filing cost in total. Last remark, you know a Chinese company, possibly, dear client of mine, they make telephones, Huawei. They sit in Shenzhen. One of the reasons why we have this giant increase in the Chinese patent filings all over the world since a couple of years, and I had the pleasure a lot to have to do with and help them to build their patent system, because they were in this situation about 12 years ago, precisely 12 years ago, where a company from the United States, Cisco, sued them out of 4 patents, and they said, oh, we need a license. And Cisco said, yeah, we give you a license, but how do you wish to pay? Which currency? And I come to what we just have heard from the speaker before. And they said, oh, it doesn't matter. Yuan, yen, US dollars, euro, whatever you like. And Cisco said, sorry, these are all currencies we don't accept. We accept only one currency, cross licenses, under your patent portfolio. And then the superiors, the board in Huawei looked around and said, our patent portfolio, where is this? Patent department, tell me. Patent department had about 12 people at that time. They had, of course, no patent portfolio, so without an own patent portfolio, no cross licenses. Very clear, so no license. And then they started a giant program. This was like the US space program after the Sputnik was circling around the Earth already, and started to file and file and file. And nowadays, Huawei files per year in China about 6,000 to 7,000 applications, and files in United States about 2,000. In Europe, I finish, maybe about 1,000. And that's it, and that might be a good example for you. It's all public information I'm giving away here to think about what you should possibly do here in the kingdom. Thank you so much.